Hello, everyone, and welcome to Thursday Talks with Chuk. Each week, we cover pressing topics that matter to you and your business. I'm Ariana Gonzalez from Chuk Attorneys and CPAs, tuning in from our San Diego office. Please join me in welcoming partner and attorney Gladys Duratio from our headquarters in Los Angeles. Hi there, Gladys, and welcome.
Hi, Ariana. Thanks for having me.
Thank you so much for taking the time today to answer our questions on this really important topic. For today's topic, we're going to be talking about recent immigration updates, the December 2025 Visa Bulletin, Gold Card progress, and proposed changes to the public charge rule. Just a quick disclaimer before we get started, I'd like to remind you that this conversation is for informational purposes only. It does not create an attorney-client relationship. So if you do have questions, please comment them below or email us anytime at info@chuk.com. We love helping you guys out with this. So Gladys, before we dive into details, can you tell us what are the biggest immigration updates people should be paying attention to right now?
Well, Ariana, there's actually a lot, but for purposes of this discussion, we're going to focus on three recent immigration updates. We have the December 2025 Visa Bulletin, which continues to show significant backlogs, especially in the employment-based categories. And USCIS has confirmed that applicants who are in the US must use the dates for filing chart for all employment-based filings this month. And then, secondly, we have the new gold card program, which President Trump announced back in September. So it's getting close to implementation. USCIS has actually finalized the new I-140G form, and the program is expected to open in mid-December 2025. And lastly, we have the Department of Homeland Security releasing a proposed rule to overhaul the public charge rule, which would give immigration officers much broader discretion in deciding who would likely become a public charge. This is still a proposal. It's not a final rule, but it's important for families to understand what may be coming. So in short, the immigration landscape is shifting in different ways.
Wow, thanks for laying that out for us, Gladys. That definitely gives us a clear snapshot of what's shifting right now. So can we break these updates down a little bit further? And starting with the Visa Bulletin, a lot of people hear Visa Bulletin, but they still feel lost. So can you explain what it is and why December's bulletin matters?
So the Visa Bulletin is essentially the government's monthly update on who can move forward in the green card process, and it controls the line. It has two charts. You have the final action dates, which tell you when green card can actually be approved, and you have the dates for filing chart, which applies to those who are in the US, and they tell you when you're allowed to submit your I-485 application, even if the approval will come later on. So for December, USCIS has specifically instructed everyone in employment-based categories to use the dates for filing chart. So that opens filing opportunities for some people who are still far from the final action dates.
Okay, that's great clarification, especially about the two charts. So now that we understand the framework, let's talk about what's actually happening in this month's numbers. What stands out to you in this month's employment-based categories?
Well, the backlogs are still very tight. EB1, EB2, EB3 have seen little to no forward movement. However, using the dates for filing chart may give some applicants a chance to file their I-485s and obtain their EADs and their travel permits. So even without a big forward movement, there's still that filing window for them.
Good to know. And many people are wondering whether they specifically can move forward right now. So for somebody inside the US, how do they know if they can file their I-485 right now?
So first, find your priority date. So check your perm and your I-140. And of course, know your category. I'm sure most EB applicants are, tracking this, the EB1, the EB2, EB3 categories. Check the dates for filing in the USCIS website, and then compare your priority date with a cutoff date for your country. So if your date is earlier than the date listed in the chart, then you can file your I-485 application this month.
Perfect. That step-by-step breakdown is very helpful. So now let's shift to family-based categories, which many of our viewers follow closely as well. Any movement here?
Family-based categories remain slow as well, especially the F2A, F3, F4. Some countries seem very minimal movement. For December, USCIS also announced that it will use the dates for filing chart for family-based petitions.
Slow movement seems to be the theme this month, and that ties into a term people keep hearing. Clients ask us a lot about retrogression. Can you help us understand what that means, and is it happening again?
So retrogression means that the government moves the cut-off date backwards, which makes fewer people eligible, right? For December, we're not seeing any dramatic retrogression. It's just more of a continuation of heavy restrictions and slow movement. So if your category retrogresses after you've already filed your case, simply waits. You still keep your EAD and your travel benefits while your file remains pending.
Okay, that's reassuring for people whose cases are already in the pipeline. Now, shifting to the employer side, what should employers and employees be discussing now, given these backlogs?
Well, for employers and employees, you want to file early on if you can. Getting an I-485 in the queue, of course, provides more stability and more benefits, even if approval comes later. And then evaluate your category strategies. Sometimes EB3 moves faster than EB2 or vice versa. Check if your employees actually qualify for EB1, where the dates are more favorable. And then there's cross-chargeability, which also helps, which is using your spouse's country of birth if the dates are more favorable for that country. So essentially think long-term, view your immigration planning as part of your workforce strategy and not just a one-off project.
Absolutely. Planning early and looking at all the angles can make a big difference. And of course, the experience changes depending on whether you're inside or outside the US. So can you help us understand how does this all differ for people outside the US who are going through consular processing?
People abroad would depend on the final action dates, not the dates for filing. So even if someone in the US can submit their I-485 now, a person who is outside the US may have to wait longer before they can actually be interviewed.
Okay, that's a helpful distinction. Now let's shift to one of the most talked about topics recently, the Gold Card program. What exactly is the Gold Card program?
So the Gold Card program is a brand new pathway to permanent residence based on making a large financial contribution to the US government. So it comes out of a September 2025 executive order and is meant to function sort of like a fast track residency program for high net worth individuals. So the government has clarified that the financial gift will actually be treated as evidence of eligibility for the EB1A extraordinary ability category, the EB2 exceptional ability category, and the EB2 national interest waiver. So the gold card does not create a new immigration, like employment-based immigration category, but is actually incorporated into the existing employment-based system. So USCIS has already finalized the form I-140G petition. And if everything stays on track, the program is expected to open for applications around mid-December.
Got it. A big program with major implications. So can you help us understand who is this actually designed for and how much money we're actually talking about here?
a lot of money. So the program is designed for individuals and corporate leaders with significant wealth. So the draft form I-140G instructions explain how the financial contribution applies to each family member. A self-petitioner should contribute $1 million for every person included in the petition. So this includes the principal applicant, be a spouse, and each child. And then if you're a corporation, you must contribute $2 million for the principal worker and $1 million for each dependent. So these amounts are on a per person basis and are separate from the filing fees, which is currently set at $15,000 for each applicant. Unlike the EB-5, this is not an investment into a job creating project. It's non-refundable contribution to the US, which is why the dollar amounts are so substantial.
Yeah, that's quite the financial commitment. Naturally, with that kind of investment, people want to know what they get in return. So if somebody does get a gold card, what immigration benefits do they receive?
Well, the gold card is intended to function as a direct path to permanent residence. Recipients should be able to live and work anywhere in the US, bring qualifying members, and eventually apply for citizenship. The government will still conduct strict background checks and financial vetting similar to the EB-5 program, but without the business risk component. I do want to emphasize that this program was initially thought of to be such a fast track way of getting a green card that as long as you donate the $1 million, you're going to get a green card. But now, based on the instructions, we know that this program is integrated into the EB-1 and EB-2 categories. So the gold card applicants have to compete for the same immigrant visa numbers that are already subject to the backlogs that we had mentioned earlier, especially for nationals of India and China. So the applicants still have to get in line. So the gold card may change the qualification process, but it does not necessarily provide a fast track option to get a green card if you are nationals of India or China.
Wow, that context is really important, especially clarifying that oversubscribed countries still face backlogs. So let's compare this to a program that people already know. Can you tell us how this is different from the EB-5 investor visa?
There are three major differences with the EB-5 program. So there's no job creation requirement with a gold card. The EB-5 requires that you provide or create 10 jobs. Gold card doesn't. And then there's a lower risk with the gold card, but higher cost. EB-5 investments can fail. You know, the gold card is a guaranteed contribution. While your money is gone, it's non-refundable, but you're not tied to a business project. And then lastly, it's potentially much faster if you're not from the oversubscribed countries. USCIS wants a gold card to be a streamlined route where EB-5 can involve long delays.
Is the gold card guaranteed to go into effect, or could it still change?
Well, right now it's moving forward, but nothing, of course, is guaranteed until USCIS releases the final instructions. New programs can face political challenges, lawsuits, or administrative delays. But right now, it seems that all signs point to a December launch.
Okay, so it sounds like it's moving forward, but still evolving. For most people watching, though, the big question is, does this even matter to them? So for the average professional or business owner, does the gold card matter at all?
Well, correctly, it does. It signals a shift in how the US is thinking about investment based immigration. It may reshape the EB-5 demand, influence economic development, and affect how future immigration reforms are designed. But for most of our clients, H-1Bs, L-1s, family petitions, the gold card won't change their eligibility.
Okay, it's shaping the system even if it doesn't apply directly to most applicants. And that does bring us to another policy area affecting many families, public charge. In simple terms, what does public charge mean?
Public charge is a rule that allows the government to deny a green card if it believes that someone is likely to depend on the government for long-term financial support. It mainly comes up during the immigrant visa process, right? During immigrant visa interviews and adjustment of status applications.
Such an important concept, especially for families. So now that there's been a lot of confusion about the old rule versus the new one, can you help us understand what did the 2022 rule say and what is the new proposal trying to do?
So the 2022 rule was more protective, let's say. It limited the public charge to cash assistance and long-term institutional care and made it clear that many common benefits like Medicaid or SNAP for children would not automatically harm an applicant. The new proposal would undo much of that. It would give officers broader discretion to consider a wider range of benefits and weigh more financial factors. The goal is to expand what could be used to deny someone on public charge grounds. So an important reminder is this is only a proposal right now. The 2022 rule still applies as of today.
Who is exempt from public charge rules even if the proposal becomes final?
So certain categories are exempt by law, such as refugees, asylees, many UT visa holders, VAWA, self-petitioners, and certain humanitarian programs. These exemptions come from Congress, so the proposed rule doesn't change any of them.
Okay, those exemptions do give people some peace of mind, but benefits usage is still one of the biggest concerns families ask us about. There's a lot of fear about using benefits like Medicaid. So should families stop using them?
Well, under today's rules, using programs like Medicaid or nutrition assistance does not automatically make you a public charge. Families should not give up essential medical care or food support out of fear based on based on rumors, right? But if someone is planning to apply for a green card soon, they should talk to an attorney to understand their specific situation. The new proposal may broaden what officers can consider, so planning ahead is important.
Thank you for clarifying that. People often do make decisions based on fear rather than facts. So now if this proposal does go into effect, what may change for applicants?
Applicants may see more detailed questions about benefits usage and stronger financial documentation requirements and more scrutiny of income, assets, education, age, even health. We could see changes to how the affidavit of support will be evaluated and whether public charge bonds become more common. So realistically, nothing would take effect until maybe sometime in 2026.
Wow, such great info today, Gladys. I want to ask you one more question. With the Visa Bulletin backlogs, the gold card emerging, and the public charge reforms on the horizon, what are your top recommendations for our viewers?
I would say know exactly where you stand, understand your priority dates and your EB categories, and monitor the visa bulletin monthly, and then plan ahead. If your filing window opens even briefly for a month, take advantage of it. If you're worried about public charge issues, get legal advice early on. And then lastly, keep long-term goals in mind. Immigration is rarely linear these days. So whether you're an employer planning staffing needs or a family preparing for a green card application, thinking a few steps ahead will certainly make the process smoother.
Wow, thank you so much for all of this amazing information today and all of your insights, Gladys. We really appreciate you taking the time to break all of this down for us. That's all we have time for today. So this brings us to the end of our conversation. Thank you everyone for joining us today. A special thank you to you, Gladys, for taking the time. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, feel free to send us an email at info@chug.com. Let us know what topic you'd like to see next. And make sure to join us back here next week for more pressing topics that truly matter to you and your business. Thank you, everyone. Stay safe and take care. Thank you, Gladys.